let's bring agreement into the modern context. I've got excited and started ahead of myself. So, we've talked about this in that last couple of minutes. Examples for instantaneous communications include telephone, telex, email. I would suggest a tweet is an instantaneous communication. A Facebook message is an instantaneous communication. WhatsApp, etc. So what are we looking at? So here, the case that we use as an example here is a 1983 case, again from the UK. I mentioned a little bit earlier, but essentially a fairly complex set of facts, but we can break them down into this. Brinkibon was in London and Stahl was in Vienna. Communications happened by telex. That is a very cool, sleek, modern looking telex machine. There was a telex machine in my office when I first started working, and it was a massive mother of a beast of a thing, and it took up a whole room. But essentially a telex machine was like a fax dot matrix printer, but it was a one-to-one kind of communication. Not terribly different from a fax, a lot slower, but it was kind of a precursor to that kind of technology. And as you can see, you kind of typed onto it directly, and then it would send off to a telex address somewhere else. So the issue here was if the relevant documentation was sent from London to Vienna, when and where was the contract made? So why did they care? Because when and where the contract was made actually results in deciding what jurisdiction, so what laws applied. So the laws in Vienna are quite different to the laws in the UK. One is a civil system, one is a common law system. So the reading of the contract could have very, very different outcomes. Now, an easy way to get out of having to have this piece of litigation would have been in the actual documentation to specify what your jurisdiction was, to have what we call a choice of law clause. But presumably they didn't do that. So the telex was sent, so the postal letter, if the telex fell under the postal rule, then it would be sent from London. But if it's an instantaneous communication, or if it just fell under the general rule, then the law of Vienna would apply. No legislation at the time, and the courts found that the general rule applied. So the contract's made in Vienna under the general rule. Concerns, problems, pretty straightforward. Faxes, on the other hand, are a simultaneous communication. So we have a case there, Reese Brothers Plastics and Hammond. The fax which is sent through a telephone line from one machine to another should be treated as a form of instantaneous communication. What about email? Took until last semester in fact, before I was able to find a case that actually supported this legislation. I think because it's just not something people have argued about. But this case, I don't know how to say it, Olivalli and Flotweg. I think they just wanted their funny names to be in a case decision. And Lowe and Russell. So there was Obiter in the first case, which is the 2009 case, but Lowe and Russell last year made it very clear that email is received at the point where it's first capable of being retrieved by the addressee.
So earlier you were saying you don't even have to prove that they were read.
No.
It
Needs to be capable of, at the point where it's capable of being received. Okay? So you get receipt messages. I mean, some people are making a lot of money out of being able to pull evidence out of different people's servers and systems in order to demonstrate when things have happened and what order they've happened. But basically, one IP address sends something to another IP address. And so there are return messages. So you've got metadata that will confirm what the times are. So you know as a sender whether or not it's actually been able to hit the recipient server. You personally might not, but you certainly have, if you want to find it, the technology to do that. And at that point, yeah, well, again, if your system's set up right.
You can request a receipt. Or
Yeah, you can request a receipt, just, again, it depends on which technology, but even if you don't do that, nothing happens on the internet without a trail. Anybody got any burning concerns about this Electronic Transactions Act? Got a couple of slides here that summarise it. Alice, please.
I'm just interested, so, because it almost sounds more like the postal acceptance rule in that you're sending it out and then say, I don't open my emails for a couple of days, but if it's hit my email server, then it's considered to be received. Is that correct?
Yeah, it is in that sense. So when you think about it, it's like you can't, I guess somebody has to make a call at some point. You can't just avoid getting a notice that you don't want. Remember, these communications don't just apply in relation to acceptance. They apply in the serving of notices, the making of offers, in a whole range of different circumstances where one person is communicating in a legal way with another person. And so the law is saying, well, you know, you can't just sort of sit there and close your eyes and block your ears and just not see the acceptance. The general rule has always been, what would a reasonable bystander having the same information believe the conduct to mean? And so if you've sent an email and it's capable of receipt at the other end, the fact that you don't check your messages doesn't matter. That's just because you're a sloppy business person, doesn't make any difference to the person who's done all of the things that they need to do to communicate acceptance. But it's not enough for them to just send an email and not care whether it gets there or not. If it bounces back or they send it to the wrong address or whatever,
out of office.
that's there. It's out of, well, it's capable of receipt there, out of office.
If you've written, I'm out of office, I'm on holidays till...
I would put
this.
that back into the offer. Again, if you really want to close your eyes and block your ears, you say, okay, acceptances will be deemed to be received on the third Thursday of every month between 1 a.m. and 2 p.m. And I can withdraw the offer at any time up until that deemed acceptance point or something or other, you know. At the end of the day, you need a set of rules. That's all this is about, is providing an algorithm so that there's certainty. I think it's pretty fair end result, really, because you know when you send, if you send to the wrong email address, it's not capable of being received by the person at the other end. A lot of contracts will actually have these really elaborate sort of processes for certain type of notices. You can't send them by their email. They'll just be deemed to not be sent at all. Or you can only send to this particular address, and if anybody moves position, then you actually have to give a formal notice under the agreement to change the address. Sorry, SJ.
Just a hypothetical in this kind of scenario. So say if, like, you've been negotiating a contract with somebody from a particular email address, and rather than use the email address that you've been using or whatever, some administrative error means that it's another, like a personal email address that's still yours, but not one that, and say there's nothing specified in notices as to...
So say we're negotiating an agreement of some sort and you're doing it with, and for some reason I send you my personal email address instead of my RMIT email address. Let's say we're negotiating an agreement about an extension, for example, where I'm a representative of the university and I mistakenly somehow send you something from my personal email address along the way, or you send it to me on whatever.
Exactly.
Yeah, that sort of scenario.
And then in that instance, if it's not an email address that you check, say it's not one you're expecting to receive, or it's one that you haven't used for years because it's like Candy Crush 09 or whatever, how would that work for...
Well, what do we think, guys? What do we think if people are changing the email address along the way? What other, I think there's another contract law principle that comes in there.
You have to tell the other party.
Sorry?
You have to tell the other party.
Well, if you're changing your address, but SJ's talking about the circumstance where, let's say she's dealing with me in relation to RMIT business, and then for whatever reason she ends up sending me an email at my law firm address instead, which I'm not checking all that often. I'm too busy checking your emails every day. So so say I've made her an offer and she's accepting it. What's happening?
It's just that acceptance has to be clearly stated. If you put your name on the email, it doesn't know which email address it's on.
Well, I think it's a little bit, I think you're on the right track, but I think it's a little bit more complex than that because there's a couple of things going on. Normally, in commercial matters anyway, whilst we deal with humans, we're contracting with entities. Okay, so if we're negotiating something to do with our RMIT life, and I happen to have a different life as well, and it goes, so you're notifying RMIT under one email address, you might be dealing with the same human under another email address, but outside of the organisational capability. So if it's not a personal contract between us, if it's a contract between you and the university, saying, I'll use extensions as an example, I have authority as a coordinator of a subject to grant extensions in certain circumstances. Please look at the policy before you ask me, by the way. But if I did that, if I were to send you and accept and say, agree to an extension and send it under the wrong email address, you might have a problem if I were to renege on that later on, because of course I can't find your extension in my RMIT account and I've forgotten that I've done it, and I basically penalise you, you go to appeal, you would have great difficulty showing a communication to the university because you've sent it to somebody who works somewhere else. So that's the slightly, because communication has to be your acceptance, or the communication has to be to the offeror. So we also have to think about email communications, who are actually contracting with. That might be something you want to think about in the assignments too, is who would the contracts be with? We deal with humans, but humans are usually or often, not always, but humans are representing the companies that they work for or that they own. So there's that kind of issue. But at the end of the day, if it was just me, personal contract with me, and I have way too many email addresses, you could communicate with me with any of them. At the end of the day, if we were just communicating between ourselves, I think the rule is the same, that just because I don't check one email address or you don't check your Candy Crush email address or whatever it is, that doesn't matter. If it's reasonable, if you've communicated
From that email address.
And I've responded to that email address. Now, if I looked at it, if I went and found it somewhere else and communicated, and it's never been part of the communication, I think it'd be a bit harder, because what we're using a objective test. What would a reasonable person having the same knowledge expect? If a reasonable person would look at all of the communications from your end of being from xyz.com.au, and all but one of my communications been back to you at that address, except for the one key one, which was at gmail.com, and it turns out you don't look at Gmail, I think a reasonable person would say, well, actually, you gave no inference there. Just the same as if all of our communications had been by email and you said to me, I need to know whether you accept as soon as possible, and so I put a letter in the post immediately, but this is the first time we've ever communicated by post, and you go and sell whatever it is to somebody else that day, then I think a reasonable person would say, well, actually it was reasonable, and you revoke the offer, and I said, but I've already accepted it. I think we've got another set of issues there, that it was reasonable for you to revoke the offer in those circumstances, because a reasonable person could see that post was never contemplated as a method of communication between us. Is that helping or confusing you all? Both. Okay, let me have a quick look here as to what I want to look at.
The confusion comes is in your cornerstone postal case is the wrong address. So the person sends the letter to the wrong address.
Oh, that's right, he does too.
It's a couple of days
Yeah,
delayed.
And he had his couple of days delay.
Yeah, that's a cornerstone case to say when you send it.
That's a good argument.
You send it from, even though to a wrong address, is the contract. And that's where he's either stiff.
No. I stand corrected. I think that's right. I think, with email you'd have a more significant issue though, sending to the wrong address on email, particularly if you've got an email exchange.
Well, again, if you're talking
But
about
again-
a person, you'd say, why didn't you send it to both persons? If you're going to flip and change something,
Yeah.
why don't you do it to both addresses? So at least they got it.
Mm.
So that's where I think
Yeah.
you're
And you see that all the time. You see that all the time.
You never received it.
No, but I'd forgotten that there was the wrong address in relation to the facts of that case. Look, and some of these cases, they're old, they're troublesome, and we don't have the benefit of knowing exactly what evidence was put in front of the judges. And some of them, I think, I have political issues with some of them. I think Crown and Clark, for example, I think, okay, the principle is good, it sort of makes sense, but at the end of the day, there is an element of, well, we don't want this is not the kind of guy that we want to pay a reward to. But the reality is, rewards are set up to attract the underbelly to come out and dob on their mates, right? So why are we saying we're not going to pay this guy when we're paying somebody else? The one that really gets my goat is one of the consideration cases that's coming up shortly. I'm going to say it incorrectly, but it's Himachan, Parmachan and somebody or other. And I'm absolutely convinced if, Lord Muckety Muck had been the lender and Mr. Himachan's son had been the borrower, that the result would have been around the other way. I think it's a clearly racist decision. Like we're just going to change the law in a particular way because an Indian moneylender's been ripped off and has had the audacity to go to the House of Lords. Like it just pisses me off, that particular case. But at the end of the day, we end up with the law. And somebody who's made a deeper inquiry into the case and, might be able to convince me otherwise, I'd welcome the opportunity. But I think the law we get when we're dealing with the common law comes out of the cases that go before the courts. And we can't choose what they're going to be. We might be able to look at the law in advance and think, well, that just sucks. In these particular sorts of circumstances, there's going to be a wrong or an injustice done. But unless and until we get a set of circumstances that we can put in front of a judge that are exactly the right test case, we've got to deal with the law that comes out of the decisions that we've got. And particularly in a slow-moving area like contract law, we're dealing with cases that are hundreds of years old. And sometimes I think we need to call them out. And I think we do see some decisions that do that. Speaking of which, I want to move on to the Battle of the Forms.